Shall we pray? Dear eternal God, our compassionate guide, the source and sense of our human striving, it is with gratitude and joy that we gather to celebrate the existence and the noble history of the North Carolina Supreme Court. Your grace has been bestowed upon this distinguished body for 200 years since January 7th, 1819. We applaud the just decisions, the defining legal work, the good counsel, and the critical insight across this significant time frame to protect, to guide, and to empower the citizens of our great state. May your amazing grace continue to guide the outstanding justices of this generation as we face new struggles, new challenges, but also new opportunities to adhere to the words of the Old Testament prophet Amos as he appealed to people of purpose and goodwill of his own generation. Let justice roll on like a river and righteousness like a never-failing stream. We especially thank you, Lord, for the exceptional justices that now sit upon this august court, and pray for each of them as they work diligently to extend the hand of justice to all of God's children, regardless of political alignment, cultural background, racial heritage, class status, or gender identification. May each one sense your presence with them as they seek not only legal guidance, but also, most importantly, divine guidance. For these times in which we live and stand in dire need of justice, restoration, and liberation, grant to them, dear Lord, strong resolve to address the most difficult questions of law. Grant them courage to stand for what is right and for what constitutes truth, and the wisdom to know the difference. May we all who seek freedom from terror, equality and fair play, right living, and a compassionate community know the promise of divine presence in our pursuits, uttered in the words of the Prince of Peace, "Lo, I am with you always, even until the end of the age." In his name we pray, amen. Amen.
Lieutenant General Buster Lawson, veteran of Operation Desert Storm and the Vietnam War, will lead us in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Bicentennial Anniversary. God save the state and this honorable court.
On behalf of the entire court, I welcome each of you to this special ceremonial session to commemorate the bicentennial anniversary of your Supreme Court. We are grateful for your presence with us to celebrate this most important occasion. I will not undertake to recognize by name all of our distinguished guests so that our collective attention may be appropriately focused on the celebration of our court's 200th anniversary. However, no ceremony would be complete without the support of my wife, Kim Martin, and the spouses of our associate justices. Justice Newby's wife, Macon Newby, Justice Hudson's husband, Victor Farah, Justice Beasley's husband, Curtis Owens, Justice Morgan's wife, Audrey Morgan, and Justice Earle's husband, Charles Walton. As always, we are very pleased to have with us former Chief Justices and Associate Justices of this court and their spouses. Chief Justice Sarah Parker, Chief Justice Henry Frye and his wife Shirley, Chief Justice Jim Exum, Associate Justice Barbara Jackson, Associate Justice Bob Edmonds and his wife Linda, Associate Justice Bob Hunter, Associate Justice Patricia Timmons Goodson, Associate Justice Bob Orr and his wife Louise, Associate Justice Franklin Freeman and his wife Lynn, Associate Justice and current United States Circuit Judge Jim Wynn, Associate Justice Willis Witchard and his wife Leona, and Associate Justice Phil Carlton. We also welcome current AOC Director Judge Marion Warren and all former AOC directors. We also welcome Chief Judge Linda McGee and the members of the Court of Appeals, as well as judges from the Superior Court, the District Court, and Office of Administrative Hearings. From the federal bench, in addition to Judge Wynn, we welcome United States Circuit Judge Allison Duncan. We are delighted to have with us Governor Roy Cooper, Lieutenant Governor Dan Forrest, and members of the Council of State, including Secretary of State Elaine Marshall, Attorney General Josh Stein, Superintendent of Public Instruction Mark Johnson, State Treasurer Dale Falwell, and Commissioner of Insurance Mike Causey. We are pleased to welcome deans from our law schools, as well as leaders of the North Carolina State Bar and the North Carolina Bar Association. We also welcome representatives from the Equal Access to Justice Commission and the Chief Justice's Commission on Professionalism. Last, but surely not least, we welcome all former research assistants and court staff. Welcome home to you all. I also want to recognize and thank Reverend Dr. Harshaw for his participation in this momentous occasion and for his regular support of the court. We are further honored today by Lieutenant General Buster Glossen's participation. After graduating from North Carolina State University, General Glossen served in the United States Air Force from 1965 until 1994. Notably, General Glossen was the principal architect of the complex and extremely successful air campaign that led to victory for our forces over Iraq in the first Gulf War in 1991. General Glossen, thank you for joining us today, and thank you for your long and distinguished service to our country. A 200th anniversary is a remarkable achievement in the life of any institution. It's a cause for celebration. It's also an opportunity for deep reflection. How did we get here? And how should we proceed? Noted American historian David McCullough once reflected that we have to value what our forebears did for us, or we're not going to take it very seriously, and it can slip away. Neither the past success nor the future survival of this court should be taken for granted. One such moment of reflection also took place on the very first anniversary of this court. Then State Senator and future Justice of this court, William Gaston, reported to the General Assembly the progress of the nascent institution. He remarked, "Ours is emphatically a government of laws. These are the universal and the only rules of action. It is indispensable that they be so expounded as that in their control of civil conduct, they shall have a steady and uniform application. There is no model by which the different tribunals of justice through the land, held by various persons, can be made to concur in the same exposition of the public will, other than by establishing one Supreme Court." Throughout its history, this institution has sought to remain true to Justice Gaston's ideal that it provide steady and uniform application of the laws of this state. The women and men who have served in this court have done their best to fulfill that solemn obligation, to faithfully adhere to precedent, to administer justice, and to strengthen the rule of law by upholding it in their own time. The great Roman statesman and orator Cicero once wrote that nothing counterfeit has any staying power. Over the past 200 years, our state has revised its constitution multiple times, changed the way that members of the court are selected, and witnessed extensive shifts in law and society. Yet this court has exhibited a remarkable staying power through it all. That we are here celebrating a bicentennial anniversary is itself a testament to this institution's steadfast commitment to consistency, fairness, and justice. It is also a testament to the justices' tireless efforts to earn the public trust and confidence of the people that they serve. So with our celebration of this hallmark anniversary comes a friendly admonition and charge for the future that is as applicable now as when it was first given. In Federalist 78, Alexander Hamilton posited that the judiciary is the least dangerous of the three branches of government. As such, he theorized that the general liberty of the people can never be endangered from that quarter. But Hamilton, like any good lawyer, noted that his thesis came with an important caveat, that the judiciary remained truly distinct from both the legislature and the executive. With this warning in mind, he went on to urge that the courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. Now, if Reverend Dr. Harshaw were up here, he would likely remind us that God has made each person unique. So how does that individuality intersect with the objectivity sought in Federalist 78? Each of us, as unique individuals, and thus as unique jurists, may not always administer the principles of Federalist 78 in the same exact way as other judges. But the key is that we each strive to do so, that we understand that the judicial office is not a political office, that courts are a co-equal branch, but with a different function than the legislative and executive branches. We understand that judges should defer to the other branches on issues of policy as long as constitutional standards are observed. That by assuming a seat on this bench, we lay down our preferences and opinions in joint pursuit of upholding the rule of law. But if judges do strive in good faith to observe the principles of Federalist 78, then the courts will, in fact, be the least dangerous branch. It has often been quoted that freedom is a fragile thing and is never more than one generation away from extinction. It is not ours by inheritance. It must be fought for and defended constantly by each generation. Our freedoms as Americans are secured by the rule of law, by respect for our Constitution, and by each of us doing our part to promote and support the public good. The members of this court are the ultimate guardians of the rule of law in this state. So it is the responsibility of the members of this court, both now and in the future, to heed Hamilton's charge, to decide each case as the law requires. In so doing, I am confident that this court, my colleagues, and our successors will continue to secure the freedoms of North Carolinians and to provide justice for all. I am optimistic that our continued fidelity to the rule of law will ensure that North Carolinians have even more reason to celebrate this institution 100 years from this historic day today. At this time, it is my distinct honor to invite His Excellency, the Honorable Roy Cooper, Governor of the State of North Carolina, to deliver greetings.
Mr. Chief Justice, Justices of the Supreme Court, and to all the people of North Carolina, may it please the Court, I am honored to be a part of this celebration today, commemorating the 200th anniversary of the North Carolina Supreme Court. So many great North Carolinians have served on this esteemed court. They have shown deep respect for the law, as well as deep love for our state. The work of this court has left countless lasting impacts on the lives of everyday people, on the way we govern ourselves, and on how we define and administer justice. This court has decided disputes between people, corporations, the state versus the accused, people with a grievance against the state, and disagreements between branches of governments. This court has been unafraid to do what it thought was right based on the law and the Constitution, regardless of whether it suited popular opinion at the time. For example, before the abolition of slavery, this court overturned the conviction of an enslaved North Carolinian accused of murdering a slave owner by finding that the legal doctrine of self-defense could be used. Before women were granted their long overdue right to vote, this court granted to Tabitha Holton a license to practice law, opening the way for more women to enter the profession. This court has expanded the rights of working people who were hurt on the job, and this court held fast to our Constitution, finding that every child in this state is entitled to a sound basic education, no matter who they are or where they live. This has been and will continue to be, with you justices here, a place to seek justice. When government becomes too heavy-handed, this court can find violations of due process of law. When unlawful discrimination takes place, this court can be a remedy. When politics and big money suffocate the rights of everyday people, this court can be an equalizer. Due process, equal protection, justice. These should not and must not be mere words. This court makes them reality. I'm pleased that the court has marked this 200th anniversary as a time to educate North Carolinians about its critical importance, myself included. I did a lot of reading, Mr. Chief Justice. This court may be housed in Raleigh, but its vision and its service extends statewide. To underscore that this is a court for all of North Carolina, you have held special sessions from Hendersonville to Newbern and many places in between, helping spread knowledge and awareness of our justice system. Above all, this court works to uphold the virtues of fairness and justice for all North Carolinians. To the justices, the clerks, and staff of this great institution, I'm deeply grateful for your wisdom and your service. Congratulations to the North Carolina Supreme Court, all of its present members and previous members, on the achievements of the past 2 centuries. May this court continue to bring justice to the people of North Carolina for centuries to come. Thank you very much.
Thank you, Governor. It is now my honor to invite the Honorable Dan Forrest, Lieutenant Governor of North Carolina, to come forward and deliver greetings.
Justices, Governor Cooper, distinguished and honorable guests, it is truly an honor to have this opportunity to speak to you on this solemn occasion of the Supreme Court's 200th anniversary. It is a testament to the strength of the ideas of our fathers that there should be 3 separate and distinct branches of government. And it is a testament to our people that we have upheld this unique structure for more than 2 centuries. As James Madison said of his separation of powers, it is because men are not angels that we need this form of government. And it has stood the test of time because it has served the people well. The executive, legislative, and judicial branches of government work together for the good of all North Carolinians, and sometimes work against each other for the good of all North Carolinians. And that is the way that it was intended to be. How is it that a government can work so well for so long? It is when we hold true to the guiding principles on which the government was founded. The executive branch must execute the laws and not attempt to adjudicate disputes or create law by fiat. The legislative branch must create the law rather than attempt to execute those laws or serve as judges over disputes. And of all the branches, the judicial branch must show extraordinary restraint. A Supreme Court justice elected by the people, serving the longest term of any elected official, must wisely resist human impulses to make laws or to execute them. Justice Exum, who's with us today, who would later become Chief Justice, said it best. The role of the legislature is to balance the weight to be afforded to disparate interests and to forge a workable compromise among those interests. The role of the court is not to sit as a superior legislature and second guess the balance struck by the elected officials. Rather than rebalancing, the court's role is only to measure the balance struck by the legislature against the required minimum standards of the Constitution. The North Carolina Supreme Court is to be commended on its long and distinguished history of fulfilling its duties with the highest integrity. The Supreme Court is also to be commended for its long and distinguished history of judicial restraint. There is little doubt that the justices that sit before us on the bench, or those who have previously served in this capacity, when presented with a case, had they held an executive or legislative office, may have chosen a different direction. But because the actions of other branches of government did not violate the Constitution, the opinion of the court has given way to those branches that are the closest to the people. That is what we call judicial restraint. That is why our system of government has worked for the best interests of the people and not just the best interests of the judges. The three branches provide accountability, and all three branches are accountable ultimately to the people. We are here today in the Justice Building. The idea of justice is as old as recorded history. As the prophet Micah said, "He has told you, O man, what is good. And what does the Lord require of you? But to do justice, and to love kindness, and to walk humbly with your God." What is justice? It is doing what is right according to the law. Lady Justice adorns many of our courthouses across our great state. She stands with scales in her left hand and a sword in her right, ready to weigh the facts and render judgment. But importantly, Lady Justice is blindfolded. When justice is at stake, socioeconomic status, race, political affiliation are of no consequence to her. Justice sees no color, no creed, no race, no party. Justice does what is right according to the law, based on the facts before her. In fact, in the center of the seal of this very court stands a blindfolded Lady Justice, showing the court's commitment to equal justice for all under the law. And with that, I congratulate you on this momentous anniversary and encourage you to continue the long-standing and honorable service that this court has provided to the people of the great state of North Carolina for 200 years.
Thank you, Lieutenant Governor Forrest. I want to pause and thank Governor Cooper and Lieutenant Governor Forrest. We are all aware of your very demanding schedules, and we so appreciate your presence with us today. Each year, the justices employ law clerks, or research assistants, as they are now called, to assist them in researching the cases which come before the court. The 1 or 2 years that these young attorneys spend with the court is the beginning of what hopefully will become a rewarding career in the law. Today we have the privilege of hearing from one of the court's first law clerks. Dewey Wells clerked for the Supreme Court in 1954, and we welcome him back today to share that experience with us. Mr. Wells, the floor is yours.
It please the court. If the program were correct and complete, I suggest that as it pertains to my part of it, before the word remarks might be the word light, because there will be nothing profound in what I have to say. And after my name would go a comma with the words ancient relic, because the mid-1950s was a simple but very enjoyable time of existence. And that's what I'm here to reminisce about a little with you, and thank you for asking me to do that. My first appearance in this court was in September of 1954, when the judges had employed me as the law clerk for the court. And I appeared here to be sworn in as a licensed attorney by Chief Justice Maurice Victor Barnhill. After that ceremony, and for the next 12 months, working for the various judges, I had from time to time suggested to me that I come in and listen to arguments in certain cases that they expected would be interesting and somewhat complex maybe, and they thought that would give me a heads up on it. And then when the justice who had drawn the case to write an opinion would have me in to discuss it, he would ask for my impressions, which I enjoyed giving, and I appreciated the attention and apparent interest that the justice had. Thereafter, in the decades that followed, when I was here to argue a case, it was my earnest hope that the justices would then be as interested in what I was having to say as they had in 1955. Well, now 64 years after that first appearance, I am honored to have a few minutes here. I stood in awe of the 7 giants of the profession who had hired me. They were, in addition to Chief Justice Barnhill, who is a native of Halifax County but established his work in Nash County, Judge J. Wallace Winburn, Chowan County originally, but wound up in McDowell, Justice Jeff Johnson of Sampson County, Emory Denny, originally of Surrey and then Gaston County, Carlisle Higgins of Allegheny County, and nothing he liked better when he was not at his desk here was to take his rifle and scope up to the foothills of Allegheny County and shoot groundhogs in that rolling foothills country. He and I had some interesting conversations about that. R. Hunt Parker of Halifax and William H. Bobbitt of Mecklenburg. Their stature, which to me, under those circumstances, was enormous, may have been enhanced by, among other things, that they were the 7 only appellate judges in the state, and generally they had a long tenure in office. They were usually appointed by the governor and then retained in office by elections, very predictably winning this, in this being then a one-party state. In rare contested elections, I recall one that was probably as famous as any in my life for a seat on this court between Hunt Parker and William H. Bobbitt, both eminent Superior Court judges. Well, Hunt Parker won that election But not long thereafter, Bobbitt was appointed to fill a vacancy, so both were on the court together, and they were good friends eventually. Fortunately for the state, Bobbitt became a member of the court. Fortunate for me, because my office was between the elevator and Judge Bobbitt's office, which is the first one on the left. And I not only got to work with him a lot, but he was a very chatty person, and I enjoyed being his neighbor. And then, of course, his being on the court was fortunate for another reason when Justice SUSIE Sharp came into the court. In those days, I was enjoying myself to such an extent, I remember wondering why I should even be getting paid for doing it. And I wasn't being paid very much at that. After 3 months here, the chief called me in to commend me for my work and said that the court had decided to increase my pay to the statutory maximum. And so, beginning January, I began to draw $300 a month. I might have received a house salary had I stayed in Raleigh and worked for the state, because the chief began to talk with me about the perceived need for administrative help to the Chief Justice in running what was then a much simpler court system, but still it was making inroads upon his time to decide cases. And they were thinking about hiring an administrative assistant. I think in those days there were maybe about 30 or 32 Superior Court judges. I think they're now over 100. Anyway, I did not say in Raleigh to do that, even though they were kind enough to suggest that I might want to stay over and do the administrative work. But probably more as a result of that, I watched what was happening in Raleigh with respect to the need for administrative help for the court. And they did begin to hire administrative assistants. But it was 10 years later when, by constitutional amendment, the administrative office of the courts was set up. And that's now history, and it has become quite an institution in itself. Some other personalities of the court in those days were John Strong, the official court reporter. He had an office down on the east end of the second floor, the only office on that floor that was not occupied by the Attorney General. And in that office he would sit and he would read the opinions of the court, and he would make notes on 3x5-inch index cards. And he would organize those cards in a retrievable way, and from those cards came the head notes of the published opinions. And from those head notes came the set of books that John Strong ultimately published, which was a very helpful set of books in those days called the NC Index. And if you remember that set of books, you're not young anymore. There are two very fine friends I made here that I must mention. John and Henry, the court's custodians. There was no marshal in those days. The custodians had a little desk out here between the elevator and my office. My office is now the marshal's office. Anyway, John and Henry were really great companions, and I enjoyed my year here, passing their desk several times a day. They taught me, among other things, that Judge Hunt Parker's presence on the floor could be detected by the aroma of his Turkish cigarettes. I called it aroma. They called it more akin to the burning trash pile. And he would light those cigarettes only with British wooden matches. Judge R. Hunt Parker was quite an individual. I'm glad I got to know. My ex officio responsibility as law clerk was to be secretary of the Judicial Council. That body was created by statute to study the judicial system and procedure and make recommendations for improvement, which they were very capable of doing. There were some fine people, people like Bill Womble, Fred Helms, and I could go on and on, but they were wonderful people, and it was my pleasure to meet with them occasionally. And I remember one of the subjects that was on the table for discussion was the Missouri Merit Selection Plan, which had been around for a decade or more by then. And the subject was whether or not that would be good for North Carolina and whether they should recommend it to the legislature as a constitutional amendment. It never got to the point where they prepared a bill, but they were very much interested in it. And I find it noteworthy that after all those years, we are still talking about reform in judicial selection in this state. I think that's worth pondering, you know, but that's a story for another day. So, in the 1955 session of the General Assembly, the Judicial Council's bills were being lobbied by a young man less than 1 year out of law school. I was as much in over my head in those days as I am now addressing this august assemblage. And I thank you for listening.
Thank you, Mr. Wells. We next welcome Gray Wilson, President of the North Carolina State Bar, to deliver greetings from the bar.
May it please the court. The North Carolina State Bar is a creature of statute, but historically this government agency has been subject to the welcome oversight of the North Carolina Supreme Court. I say welcome because we at the State Bar take our obligations as a self-regulating body quite seriously. And we look to the court for guidance, wisdom, and counsel as we strive to perform our solemn statutory duties to the legal profession and to the public that we are sworn to protect. Hardly a quarter goes by when we do not propose changes and amendments to State Bar regulations, which this court has the sole and exclusive authority to approve. Now, this is hardly a sterile process. We regularly meet and confer with the Chief Justice about programs and issues on which we seek his advice, and he has always been open, accessible, and willing to consider whatever proposals we bring to the court. Perhaps the best example of this close relationship is that within a couple of days of being sworn in as president of the State Bar, I received a request to provide my cell phone number to Justice Martin, which was quickly followed by a pleasant telephone call to tell me that he hoped that the relationship of these two entities would remain as cordial and as engaging as it has been in the past. And I can assure you that at least for another year, it will. I will not be mortally offended if I am not invited back to this court for a celebration 200 years from now, because I believe that there will be such a celebration and that this court will still be here manning the ramparts of justice. For if there's anything that is more important than the interactive relationship between our two groups, it is the sanctity of our judicial system as the third branch of government. Demagogues come and go, and on occasion we're happy to see that happen, but the judicial system is a bedrock of our freedom, the repository of the values that we hold dear: access to justice, fair and efficient adjudication of rights and obligations in the courts, and above all, equality under the law. For in the final analysis, there is only the law. And we see many of the purveyors and custodians of the rule of law among us here today. And we honor them. We honor the judicial system. And we pray for the fair and lasting administration of justice in this state, at least for another 200 years.
Thank you, Mr. Wilson. At this time, if our technology works correctly, we will have the opportunity to watch a video with reflections on the history of our Supreme Court. Today we honor the bicentennial of our state's highest court. Over the past 200 years, our state has changed in many ways, and the court as an institution has reflected those changes. Hello, I'm Mark Martin, Chief Justice of the Supreme Court of North Carolina. As our state constitution reminds us, a frequent recurrence to fundamental principles is absolutely necessary to preserve the blessings of liberty. As we move forward into the court's third century, may these fundamental principles continue to be our guide as the Supreme Court of North Carolina remains a court of law firmly committed to providing justice for all.
Judge William Gaston, born on September 19, 1778, had a tremendous impact on the creation and existence of the Supreme Court of North Carolina.
To administer justice in the last resort, to expound and apply the laws of the advancement of right and the suppression of wrong, is an ennobling and indeed a holy office, and the exercise of its functions. It raises my mind above the mist of the earth, above cares and passions, into a pure and serene atmosphere, and a better temper to my soul. How can I better serve my country? William Gaston.
William Gaston was the first student enrolled in Georgetown University, and Gaston Hall at Georgetown is named in his honor. Gaston served multiple terms in the North Carolina General Assembly and served as Speaker of the House of Commons. In 1818, while serving as chairman of the House Judiciary Committee, William Gaston introduced legislation which created the Supreme Court, and it was through his prestige and guidance that the bill was passed and the court was created.
Be it enacted by the General Assembly of the State of North Carolina, and it is hereby enacted by the authority of the same, that there shall be appointed by joint ballot of the two houses of this General Assembly 3 judges, being men of integrity and learning in the law, who shall be styled judges of the Supreme Court of North Carolina.
Upon passage of the creating legislation, the General Assembly's next task was to vote on the court's first jurists. The Assembly elected John Lewis Taylor, Leonard Henderson, and John Hall as the first judges of the Supreme Court. Having the privilege of selecting its own chief, the newly formed court chose John Lewis Taylor, a member of the Court of Conference, a Superior Court judge, and a 2-term member of the House of Commons. Taylor served as the court's first Chief Justice from 1819 until his death in 1829. Serving with Taylor as an original member of the Supreme Court was Judge Leonard Henderson. Upon the death of Chief Justice Taylor in 1829, Henderson became the second person to serve as Chief Justice of the Supreme Court of North Carolina. Chief Justice Henderson had a profound influence on North Carolina's legal profession and can rightly be called the father of legal education in North Carolina. The third original member of the Supreme Court was John Hall, who was born in Virginia in 1767. John Hall served as a Superior Court judge from 1800 to 1818, and 3 terms in the House of Commons before being chosen to become an original member of the Supreme Court. During the past 200 years, the court has had 5 permanent homes. The first judges of the Supreme Court met in the North Carolina State House, which was located on Union Square, the site of the current state capitol. The court met in the State House until it was destroyed by fire in 1831. After the present Capitol building was completed in 1840, the court returned to Union Square and occupied the northeast suite of offices on the first floor. The corner office, presumably the largest of the suite, was used as the courtroom. The historic events in January of 1869 resulted in accusations of contempt of court, issuance of show cause orders, and the first and only time the Supreme Court has issued a warrant for arrest.
The Supreme Court said, "Mr. Adams, you must appear before us and show us why you should not be held in contempt." They ordered his arrest. The marshal, as he was escorting Mr. Adams to the jail, was asked to allow Mr. Adams to go in and see the governor. Governor Holden had several men around him, and Governor Holden and those men told the marshal that he shouldn't take Auditor Adams down to the jail. Chief Justice Pearson wrote a letter to Governor Holden saying that he was disappointed that the governor would intrude in this affair of the judiciary. The governor wrote back saying he thought that there had been a misunderstanding. Auditor Adams submitted to the court an affidavit explaining why he had held over as he had. For three of the members of the court, that was adequate. But for Chief Justice Pearson and for Justice Reed, that explanation was inadequate.
In 1888, the court moved from Union Square to its new home in a newly constructed two-story court building on Edenton Street in what is now the Labor Building. It was at the court's first meeting at this location that the custom of portrait presentations for former court members was established. In 1914, the court moved to the new administration building on the west corner of Morgan and Fayetteville Streets. As the court outgrew its space, a new building was constructed across Fayetteville Street and was dedicated in 1940 as the Law and Justice Building, where the court has met until the present day.
Unlike now where a law clerk is assigned to one of the justices, I had the privilege of working for all of them, some more than others. The concept of a law clerk had not been around long enough for some of the justices to feel completely at liberty to farm out the work. Others were more eager to do so, but I enjoyed working with all of them.
Throughout its history, members of the Supreme Court have shared more than the offices and courtrooms they inhabited. Many enjoyed close working relationships, and a few justices shared family ties.
I talked to Granddad a lot about his service on the court. I was fortunate enough to live until he was 88 and I was 29. I even got to try a case with him as a young lawyer when I first got out of law school. Those of us who serve on the court and those of us who work here consider each other the court family. But there have been real family connections associated with the court over the couple of centuries of its existence. There have been father and son combinations to serve on the court. Justice Henry Groves Connor and his son Justice George Whitefield Connor, and Justice I. Beverly Lake Sr. and his son Chief Justice I. Beverly Lake Jr. There have also been two grandson-grandfather combinations who served on the court. The first was Justice William Blunt Rodman and his grandson William Blunt Rodman Jr. I'm rather familiar with the second one because it involved my grandfather, Samuel James Irving Jr., who served on the court from 1948 until he was appointed to the United States Senate in 1954, and me. I was elected to the court in 2014 and began my service on January 1, 2015.
The longest-serving justice was Chief Justice Walter Clark, who served from 1889 through 1924. Of the 28 people who have occupied the center chair as Chief Justice Walter P. Stacey has the distinction of being the longest-serving, having served 26 years. During his tenure, Chief Justice Stacey presided over milestones of the court, which included building the court's permanent home, the inclusion of women on juries, the decorum of justices wearing robes, and the expansion of the court from 5 to 7 members. Susie Sharp was the first woman Superior Court judge in North Carolina. In 1962, Governor Terry Sanford appointed Judge Sharp to the Supreme Court of North Carolina, making her the first woman Associate Justice of the Supreme Court. In 1975, Justice Sharp became the first woman in the nation to be elected as Chief Justice of a state court.
You know, it always puzzled me as why people thought there was any question about what to call a woman judge. But they would invariably inquire, how should you be addressed? And I said, just call me anything except that woman. Mm-hmm. But I didn't particularly like to be called Miss Judge, because I didn't do that any more often than I could help. And sometimes they would say, Madam Judge, with the French accent. That was good.
On February 3, 1983, Henry Frye was administered the oath of office and became the first African American to serve on the Supreme Court of North Carolina. In 1999, Governor Jim Hunt appointed Justice Frye as Chief Justice, and Henry Frye broke a new barrier and became the first African American Chief Justice of the Supreme Court.
Well, after I had been on the job a few weeks, I called the former Chief Justice Burley Mitchell and asked him if he wanted the job back. There are a lot of things that are really difficult. There's some that are very challenging, and yet it's the kind of thing, I guess, that you say, well, this is the greatest opportunity I've ever had in my life.
At the time of the centennial celebration of the court in 1919, the court met in what is now the courtroom for the Court of Appeals, and justices and bar leaders attempted to predict what the court would look like today. Justice Robin Hudson and Justice Sherry Beasley reflect on those predictions.
Prominent Raleigh attorney Thurston HICKS, in his 1919 address, predicted the following: the growth of our population and increase of judicial work will in the next century increase our Supreme Court judges to 9, 2 or 3 of whom will no doubt be women.
We've seen enormous increases in the participation of women in the legal profession, both as lawyers and on the bench.
The progress of women serving on the Supreme Court of North Carolina, as well as the Court of Appeals, is somewhat reflective of women in the practice of law.
So I think the higher you go in a lot of law firms, the fewer women there are at the very top. That has not been true in the judiciary.
The Supreme Court of North Carolina is truly an historic institution of the highest calling. To recall a former justice's words as he reminded his generation about the noble work undertaken by the Supreme Court. We must remember that a civilization is founded in law, that law is administered by the courts. The effectiveness of the courts is dependent upon popular respect and moral support. And the independence of the judiciary is the surest safeguard of the people's rights. If we disregard these elemental facts, the day may come when stable government shall perish from our land. Those words still ring true today. The court is the ultimate safeguard of the people's rights. To the men and women who have served on our Supreme Court over the past 200 years, I say thank you. We now turn our faces toward the future and look forward to many more years of providing justice for all.
Well, I hope you agree that this was a wonderful tribute to our Supreme Court, and I'd like to pause just for a moment. Obviously, videos don't just spontaneously come into existence, and to really thank everyone who helped make and present the video today. This includes Sharon Gladwell and her staff at ASC Communications, Chris Mears, Andrew Breedlove, and Jason Dallin, Mike Collins and Dick Ellis, Dewey Wells and Fred Wood, who helped us in the courtroom today, and of course, Justices Newby, Hudson, Beasley, and Irvin. Why don't we give all of them a round of applause? In addition to being a member of the NC State Bar, attorneys in our state also have the opportunity to join the North Carolina Bar Association. Jacqueline Grant is the current president of the North Carolina Bar Association, and I am pleased to invite her to come forward and extend greetings to the court at this time.
May it please the court, it is a true honor to be here today with you to help celebrate your bicentennial anniversary. I bring you greetings from the North Carolina Bar Association and the Foundation. Since its inception, the Bar Association has enjoyed a unique connection to this court. The organizational meeting of the Bar Association was held in the Supreme Court building on February 10th, 1899. It was in the courtroom of this court that our association began our mission of service to the profession and to the public. 4 of our charter members at that time later went on to serve on the Supreme Court. That included Henry Groves Connor, Walter Clark, Harriet Clarkson, and Platt Walker. And from the beginning, our organization has been proud to support the initiatives of this court to help promote the administration of justice and judicial independence. In the recent years, some of the initiatives that we have supported has included the support of the North Carolina Commission on the Administration of Law and Justice. We were proud to host the convening event at the Bar Center and to support its work through the participation of our members, and by promoting and working to support resulting initiatives of the Commission, including Raise the Age. Prior to the Commission, through our Open Courts Committee, we worked to support the Supreme Court and the judicial branch by raising awareness about the work of the court and our judiciary and advocating for increased resources for the judiciary. From the beginning, we have worked to promote and communicate initiatives of the court and the Chief Justice to help advocate for the importance of an independent judiciary. We recognize that an independent judiciary is a cornerstone of our democracy. In order to have a fair and impartial judicial branch, a judge's actions should be free from outside influence, which includes being free from fear of political and social backlash. Judicial independence seeks to insulate judges against political forces, including the legislative and the executive branches, that might seek retribution for particular judicial decisions. And this is one of the efforts of the Bar Association that we will continue to champion as we move forward and to educate the public on the importance of judicial independence. We remain proud to have the Chief Justice state the judiciary address at our annual meeting. We also look forward to our quarterly meetings with the Chief Justice to discuss initiatives of the court and how the Bar Association can assist this court and the judiciary in promoting and carrying out those judicial initiatives. We congratulate the Supreme Court on its 200th anniversary. We look forward to the next 200 years of this court providing the great service that it has done to North Carolinians, and you have the support of the Bar Association, and we look forward to working with you. Thank you,
Ms. Grant. Now, our next speaker is no stranger to the court, having served as an Associate Justice from 1986 to 1998. He is my predecessor. I assumed his seat on the court when he retired in 1998. Justice Willis Wichard will share with us remarks on the history of the Supreme Court.
Thank you, Mr. Chief Justice, and may it please the court. In 1977, I was a member of a Southern Legislative Conference delegation to China. Welcoming remarks informed us that there was so much to see and learn that the experience would be like, quote, looking at the flowers from a galloping horse. Today, our brief venture through 200 years of North Carolina Supreme Court history will require an even faster horse to accommodate the allotted time. Problems of inclusion and exclusion defy felicitous solution. But let us begin. The colony of North Carolina had a supreme common law and equity tribunal styled the General Court, which was a trial court. There was no court for appeals, though the presiding officer was called Chief Justice. On December 19, 1776, the newly created state of North Carolina adopted its first constitution. It provided that the General Assembly should, by joint ballot, appoint judges of the Supreme Court who would hold office during good behavior. The General Assembly seemed to consider that there being no appellate court, the Superior Court filled this requirement, for there was no formal appellate court until 1799. Informally, however, the state's 3 trial judges functioned as a court of conference to decide one of the more significant cases in the state's judicial history, Bayard against Singleton in 1787. In the aftermath of the American Revolution, the state had little tolerance for those who had remained loyal to the British Crown. A 1785 act of the General Assembly provided for the confiscation of property held by or through such persons. The legislation provided for commissioners to transfer such property from its loyalist owners to the purchasers who supported the newly created independent state. To prove their title, the purchasers at the confiscation sales had only to present their deeds from the confiscation commissioners. The court was then to dismiss the claims of the loyalist owners or their successors. There was a problem, however. The state constitution gave to every citizen a right to a decision in regard to his or her property by a trial by jury. The informal court of conference awarded the plaintiff her constitutionally mandated trial by jury, thereby avoiding the legislative enactment. The principle of judicial review of legislative acts for conformity to the fundamental law was thus established in North Carolina 16 years before John Marshall ensconced it into the fabric of the American experiment in self-government in his better-known opinion in Marbury versus Madison. In 1799, the General Assembly formally adopted a system under which the 3 Superior Court judges sat to decide appeals in what was styled the Court of Conference. In 1804, the court was first required to file written opinions. In 1810, the judges hearing appeals in conference were authorized to elect a Chief Justice. Any 2 trial judges, of which there were now 6 when sitting in Raleigh, constituted a quorum for deciding appeals. The Supreme Court, contemplated 42 years earlier by the Constitution of 1776, was at last created by legislative enactment in November 1818. The bill's sponsor, prominent New Bern attorney William Gaston, would later become one of the court's most illustrious members. The court's existence commenced on January 1st, 1819, and its first session was held on January 5th, 1819, 200 years ago, the day before yesterday. At its inception, the court functioned with 3 members chosen for life, subject to good behavior, by the General Assembly. The members designated one of their number as Chief Justice, and only he had the title Justice. The other members were judges. The Reconstruction Constitution of 1868 provided for a Chief Justice and 4 Associate Justices to be elected by the people for terms of 8 years. In the event of a vacancy, the governor was to appoint to fill it until the next general election. The number was reduced to 3 from 1879 to 1888, when the Constitution was again amended to provide for a Chief Justice and 4 Associate Justices. A 1936 amendment provided for a Chief Justice and not more than 6 Associate Justices. The General Assembly authorized appointment of 2 additional Associate Justices as of July 1st, 1937, and the court has functioned with 7 members ever since. John Lewis Taylor, Leonard Henderson, and John Hall constituted the original court. The members chose Taylor to be the first Chief Justice. Upon Taylor's demise, the General Assembly elected Thomas Ruffin to the vacant position. Judge Henderson became the Chief Justice and was by all appearances a popular and respected one. The court, however, was a fledgling institution and unpopular. Every General Assembly session brought efforts to abolish it. Upon Henderson's death, the election of William Gaston to the vacancy was believed to be essential to the court's survival. One possible impediment was brushed aside. Gaston was a Roman Catholic, and the North Carolina Constitution then banned from state office anyone who denied the truth of the Protestant religion. Gaston and his supporters rationalized that insofar as the Protestant religion could be defined, it was the Apostles' Creed, which Catholics also believed. The fact that they held other beliefs that Protestants did not share could be disregarded. There were further impediments, foremost among them the candidate's finances. Ultimately, Gaston was willing to, quote, leave it to a few friends to say what duty demands of me. He specified the friends: Governor David Swain and Raleigh lawyers Thomas Devereaux and George Badger. In their appeal to Gaston, these 3 played the civic virtue card. If any other name is presented, Governor Swain asserted, the Supreme Court dies with the lamented Chief Justice. Only Gaston's election, Devereaux claimed, could, quote, restore confidence in the public mind and save the court. Gaston yielded, the legislature overwhelmingly elected him, and he served the court ably for the remainder of his life. Chief Justice Walter Clark would say that with Ruffin and Gaston together on the Supreme Court bench, the court has never been surpassed in ability and reputation. Roscoe Pound, longtime dean of the Harvard Law School, would consider Ruffin one of the 10 greatest American common law judges. Walter Clark holds the record for the longest tenure of any member of the court, 34 years, 6 months, and 3 days. A noted progressive for his time, CLERK advanced the law of the state considerably in its effects on women and children. He also led the effort in North Carolina and provided constitutional analysis and argument nationally for ratification of the 19th Amendment, which granted the right to vote to women. Walter Stacey had the second longest tenure on the court, 30 years, 8 months, and 12 days. He had the longest tenure as Chief Justice, 26 years, 4 months, and 26 days. Like CLERK, Stacey was active beyond the court, particularly in the settlement of numerous controversies between management and labor, pursuant to requests from 4 presidents of the United States. For the first 143 years of its existence, the court was composed exclusively of white male judges. In 1962, Governor Terry Sanford appointed SUSIE Marshall Sharp to the court. Sharp had also been the first woman to serve as a Superior Court judge in North Carolina and would become the first woman elected by the voters of a state to be the Chief Justice of a state Supreme Court. For the first 164 years of its existence, the court had no African American members. In 1983, Governor James B. Hunt Jr. appointed Henry E. Frye, a state senator, to be an associate justice. In 1999, Frye became the first and to date only African American Chief Justice and served in that position through most of the year 2000. 3 members of this court had sons who later served on it. Thomas Ruffin Jr. followed his father, Thomas Ruffin Sr. George Whitfield Connor followed his father, Henry Groves Connor, and I. Beverly Lake Jr. followed his father, I. Beverly Lake Sr. A sitting member of the court, Sam J. Irvin IV, came to the court 6 decades after his grandfather, Sam J. Irvin Jr., left it to acquire national renown as a member of the United States Senate. Justice William Rodman, who retired from this court some 2 weeks after I came here as a law clerk, was also following a 19th century grandfather who served on the court. The establishment of the Court of Appeals in 1967 profoundly altered the nature of the Supreme Court's work. I was in the next to last group of Supreme Court law clerks prior to creation of the Court of Appeals. Approximately 2/3 of the cases in which I assisted Justice William Bobbitt would now be Court of Appeals cases, and approximately 1/3 would be Supreme Court cases. Prior to creation of the Court of Appeals, there was a right of appeal from the Superior Court to the Supreme Court. Petitions seeking review of an independent appellate court opinion were non-existent. Today, such petitions consume a considerable portion of this court's time and energy. In closing, a brief word about an institution critical to the court's functioning, the Supreme Court Library. In 1812, before it created the Supreme Court, the General Assembly established a law library for the state. The 1831 fire that burned the state capitol destroyed virtually all of the state library collection, including the law library. In January 1834, while the new capitol was under construction, Governor David Swain, as president of the Literary Fund, submitted to its board a resolution of the General Assembly requesting that the board purchase, preserve, and manage a public library for the state. Swain requested assistance from Chief Justice Thomas Ruffin, who was in Philadelphia at the time. Ruffin, however, would be there too briefly, quote, to admit of attending to this commission. As he often did, Swain then turned to William Gaston, telling him the court was greatly in need of a library. Within the month, Gaston had purchased the books for the Supreme Court Library, quote, on very fair terms. Governor Swain thus could state in the Literary Fund report that a good library, greatly needed by the Supreme Court, had been purchased under Gaston's direction. In his fourth institute, Lord Coke wrote, "Let us now peruse our ancient authors, for out of the old fields must come the new corn." In its 200 years of existence, 100 people have served as members of this court. There have been 28 Chief Justices. The 7 of you privileged to sit here today are mining the old fields initially plowed by your predecessors as you seek the new corn from which to resolve the matters the citizens of the state bring to you for decision. As the court moves into its 3rd century, you too are contributing to what will become old fields from which your successors will mine new corn. May the blessings of heaven be upon you as you do it, and may this grand old institution not only survive, but thrive in the 3rd century of its existence.
Thank you, Justice Whitcher. Well, Justice Whitcher, you in fact covered quite a bit of ground there in those few minutes. Thank you so much for your efforts in that regard. I also want to take this opportunity to thank you for all of your effort over the last several years in support of the court's anniversary celebrations. As we prepare to close the ceremonial session, I want to pause and encourage each of us to renew our commitment to be exemplars of civility and professionalism in our community, in our state, and in our nation. Let's unite in support of the rule of law. Let's promote public trust and confidence in our courts. Let's elevate principles over passion. Let's talk to each other and not past one another. Let's genuinely listen to each other and consider different perspectives. Let's be objective when deciding between opposing points of view. And when we do disagree, let's do so without being disagreeable. Even though every generation will always have reasonable disagreements over policy, this institution represents an area where we can unite together in support of the rule of law. That our written Constitution must be upheld and defended as the bedrock of all our liberties. That the law should be uniformly applied in each case and to each person. That we should strive to administer equal justice under law. I am thankful that we can come together today to celebrate the past successes of this court and what it represents to our society. And I sincerely hope that we will all actively support its continued success well into the future. I want to pause and thank each and every person for coming here today. Your presence is so special to all of us here on the bench, to all the employees and staff that not only work at this court, but to the over 6,000 internal stakeholders, the elected officials and the employees that administer justice in 100 counties of North Carolina. In a moment, the clerk will adjourn this ceremonial session. But I first would like to thank a few people who have been so helpful to the court over the last few years as we've celebrated the anniversary commemorative observances of the Administrative Office of the Courts, the District Court, the Superior Court, and the Court of Appeals. I'd like to thank Philip Miller, Buck Copeland, and Tom Davis with the North Carolina Supreme Court Historical Society, and Justice Willis Witchard and Danny Moody with North Carolina Legal History Incorporated for all their collective help in administering and supporting this event and all the other events that have been organized to commemorate our important anniversary milestones within the judicial branch. I also would like to thank Chief Judge Linda McGee of our Court of Appeals and Christy Roeder, our former clerk, and our own Terry Murray and Amy Funderburk, our current clerk of court, and all the other friends of the court and staff who have helped make this ceremony possible. Finally, I would like to thank Governor Cooper, Lieutenant Governor Forrest, Reverend Dr. Harshaw, General Glosson, Gray Wilson, Jacqueline Grant, and Dewey Wells for their participation in today's ceremonial session. Let's give them all one more round of applause. Now, immediately following the ceremony, there will be a reception at the state capitol, which is located directly across the street from this building. Those of you in the courtroom will be asked to wait until the justices and the governor have had an opportunity to leave the room, and then you may proceed to the elevator at the direction of the research assistants, and then hopefully on to the reception. The court's research assistants will be stationed throughout the building to assist you as needed. Madam Clerk, please adjourn this ceremonial session.